Karen, one of the themes which we used to justify the removal of the responsible lending laws was about reducing red tape and complexity. So I was just interested in your views. Like, we've got an APRA standard now relating to responsible lending. AFCA is still there, obviously. There's also the existing tests in the corporations law relating to diligent and prudent banking and acting honestly and fairly when it comes to lending decisions. So, a whole tapestry of different laws there. Do you, foresee an outcome, where you're still going to have ongoing uncertainty, even if this ASIC oversight of responsible lending is removed as the government is trying to push through the parliament?
Yeah, I absolutely do. I don't claim to be a responsible lending expert, but, I know that banks are working to, they're going to have to basically work to figure out what their own version of the right level of credit decisioning and what have you is based on the APRA requirements, but also probably taking into account the previous responsible lending standards. So they're going to have to really recalibrate and think about, what their risk appetite is and what they can do. Banks don't deliberately go out and loan money to people who are not going to be able to repay it, but you will always get errors, you'll always get individual problems that come up. The thing I'm most struggling with when I think about regulation, I think it's really important to think about the design of regulation and to make sure that things actually hang together appropriately. And whilst people might be quite keen on APRA sort of overseeing the prudential standards, APRA doesn't deal with individual issues. If a bank makes a mistake in a handful of cases, it's not going to cause the prudential standard to be breached, because really APRA is looking at a portfolio level. What the consumer where the consumer is really relying on is a patchwork of new and old regulation and AFCA to hopefully have a remedy if something actually goes wrong. So it's obviously diligent and prudent banker, DDO and PIP efficiently, honestly and fairly. I guess the question is going to be AFCA. AFCA has a lot of power. It has a fairness jurisdiction. How will it see? The sleeper issue is how will it see what banks should be doing, and how much will it take the old responsible lending approach into account in determining that?
I might just bring Gerard in, also in Melbourne, just to respond to AFCA. What are you seeing, Gerard, in terms of the number of cases and the types of claims going into AFCA, the Australian Financial Complaints Authority, and how is it seeking to get involved in this space and change bank assessment effectively through its decision making?
Well, AFCA is an integral institution that really having accessible access to justice for consumers is really important. But we've also got to consider it in its context. AFCA is designed to be an alternative to taking it to court, somewhere it's easier, simpler, less costly. But that doesn't mean a consumer shouldn't be able to go to court in a given case. And going to court can actually provide a bit of discipline on AFCA to be following due process and appropriate lending standards and the law, I guess. So I think if we're removing the right for a consumer to go to court, that will have an implication for AFCA's decision-making. As I said as well, AFCA's rules specifically exclude any complaints to do with credit risk. And so what does that mean? What does that mean? It's really hard to work out. They do say there's an exception for maladministration, and maladministration is interpreted as, compliance with the law. Now, if the responsible lending law is to be removed, what are we replacing it with? So there's a lot of unknown questions here, but I think it's going to restrict AFCA. I have had a look back at some of the AFCA determinations this year. I think I looked at all the home lending determinations. To be honest, there isn't one that favoured the consumer. So I'm not sure that AFCA is, necessarily causing a lot of grief for lenders out there, but it's an important place to ensure there is a level of access to justice.
Can I just come in there, Judge? Because I do think that Gerard is right, that there's still a lot of things to be tied down in this draft legislation. It's actually sounds simple, but as difficult because there's a lot of moving parts. And I do think that some consideration about what, if any, changes might need to occur to AFCA's jurisdiction is a part of getting consumer protection right in the new regime, whatever it ends up being. But I do think it's important just to remind people that the provisions of the Banking Code of Practice form part of the customer's contract and are enforceable in court. And of course, most customers with a complaint are not going to end up in court. They go to appropriately, the accessible, affordable alternative through AFCA. But I absolutely endorse what Gerard is saying. AFCA and banks, if they know there's a court option, even if it's rarely used, it does act as a good check and balance. And the Banking Code of Practice requires bankers to act as diligent and prudent bankers. And in interpreting what prudent means, the prudential standards will form, I would have thought, part of that consideration. So, yes, it's a long way to go, but banks are as concerned as consumer reps are to make sure that there are adequate consumer protections. You cannot have a robust regulatory environment if it does not adequately protect consumers. And that may well mean there's got to be some tweaking to AFCA. We've got to see what that actually looks like as it rolls out.